Welcome to The Law, Your Money, and You. I'm Roberta Sapphire, an attorney in Sharon.
I'm Camille Barron, a financial organizer, also here in Sharon. Today we're going to touch on a subject that I think is becoming more and more of an issue, particularly because we have a lot of foreign-made goods with different standards of regulation and so forth. So we're importing a lot of things into this country. And we have a guest who's going to be talking about product liability today.
Yes, we have Attorney Jay Bronstein. I have some background information on him. Jay, thank you for coming. We usually say to people, tell us a little bit about yourselves, but I'm going to say you graduated cum laude from Boston College Law School 30 years ago.
I try not to mention that. Thank you.
She did.
Right. And one of your major concentrations is the product liability law. That's why we have you, and you're a member of the state and federal court in Florida, and you have a lot of cases here from high school football players with helmets and motorcycle rides and everything. And what to me is one of the most important things to Camille and I about you is that you're chairman of the Gift to Hope.
Yes, from the Rotary Club of Sharon.
Yes,
Right.
which shows that you're a good person too.
Well,
so
thank you.
So tell us a little bit about yourself.
Well, as you stated, I went to Boston College Law School. Before that, I should give a shout out to my undergraduate college, Tulane University, down in New Orleans, where I studied for 4 years and received a great education.
And had a lot of fun.
And had a lot of fun also. Combined, that's the beauty of Tulane, you can combine both, but you have to have some measure of self-control. Following law school, I worked first for a firm, Schuman and Ross, which was originally in Boston at 141 Tremont Street. And Schuman and Ross civil litigation firm, do everything from product liability, personal injury, of which product liability is a component. Eventually, Schuman and Ross in the 80s moved out to Sharon, which at the time was quite a shock to be driven out here to what was the middle of nowhere. But it's worked out beautifully, and I now have my own firm, and I'm also of counsel to Robert Schuman and Associates here in Sharon. I did have an office in Brockton for a number of years, and now I'm right above community education. That's the best way to describe it to people right here in town. I've dedicated my practice to the civil litigation, the seeking of compensation for those who have been severely injured, whether it be from motor vehicle accidents, motorcycle accidents, industrial accidents, and also product liability related incidents.
When you say product liability, for people who don't understand, where would you say this is a product liability and this isn't? Like start with just enlighten us, like an automobile, the helmets, different things.
Yes, product liability is, I would say, a subset, if you will, of personal injury law, and it involves the injuries, personal injuries caused by defective or unreasonably dangerous products. So the components would be a product that is found to be unreasonably dangerous, along with that, or defective, and that it's resulted in a personal injury to an individual. Products, it could be any product. Common products, you mentioned automobiles. I have been involved in some rollover type accidents. And the claim in those would be that the product was unreasonably unstable, that the center of gravity, you can get very involved, but you would have automobiles that perhaps aren't crash-worthy, various factors.
Is that what starts the recalls of the automobiles, that somebody got in an accident, or do they ever get the recalls before somebody gets hurt?
I'm glad you raised that issue. The recalls traditionally are manufacturer can institute their own, and in automobiles you do see that now and then. Automobiles are a little different because you can have different government agencies that are involved with automobiles. But the major governmental agency other than automobiles that's involved with the recall of products is the United States Consumer Product Safety Commission, or the CPSC. And what happens is they receive complaints or notices from consumers. And it could either be a death, an injury, or just a potential for a death or injury that individuals report. They evaluate those when they reach a certain level or the particular risks, such as death or severe injury, or it's a certain level. They can commence proceedings where they first attempt to get the manufacturer or supplier to agree to a recall, what they would call a voluntary recall. If that doesn't happen, they can, in fact, require a product to be recalled. That's why it's very important, and that's a great resource, the Consumer Product Safety Commission. And consumers can go online. It's really important. Many products are out there that are on the secondary market, that are resold, whether it's flea markets, eBay. One of the biggest ones now, of course, is Craigslist. So the manufacturer of the product, even if, and in automobiles, people resell them. So the manufacturer might not have a way, if they become aware from reports of a hazard, they may not have a direct way to get in touch with the person who actually has the product at this point.
What if you brought up a good point? If it's a resale, how do you know that the original owner didn't do something, or they turned something wrong, or, you know, and made it? And how do you know? That must be, those are tough cases to prove. How do
Those are tough, but one thing you can do on any product you're going to buy, and I would reference most of all child products in this. I'm involved right now in the litigation in federal court against a crib manufacturer and a retailer who, a one-year-old child down in North Attleboro, tried the mattress support system in this crib failed, and there's been a lot of reports. It's in litigation, so I can't go into all that many details, but the mattress support system failed, causing the mattress to dip and allow a gap to occur between the side of the crib and the side of the mattress, and the child tragically slid down during the evening and was found in the morning. And it's hard to even talk about, but wedged between the mattress and the side and had asphyxiated.
Oh, my goodness.
What was most troubling about that, when I got involved in this case, the actual product, the parents, to their credit, did not think of themselves initially. They thought of the greater good, that this should not happen to others. And they ended up turning this crib over to the Consumer Product Safety Commission. The Consumer Product Safety Commission started a study, an investigation, and in fact recalled all cribs that contain this type of tubular mattress support system. And that's simply the bars that the mattress sits on. So what was spooky is that these cribs are no longer sold.
Oh, that's good.
They did not have the crib. They had given it to Consumer Product Safety. It's illegal, once there's been a recall, to resell cribs when these were totally recalled from the market. So how do you, as an attorney representing someone, how can you prove a case? We didn't even have the product. And the answer was Craigslist. The answer was...
Oh, you found one on Craigslist?
I found many more than one. And
the people didn't know that they were selling?
They did not know. I posted on a couple bulletin boards on child safety related sites. And to this day, a couple years later, I'm still getting emails from people who did not know that these cribs have been recalled. And it's a real problem.
So these people who are reselling it, they might be open to liability too, because they knew or should have known. Would you use that?
Well, that's that's being a lawyer, you know, that's for negligence. That is the common phrase.
That's
knew or should have known. I have not heard of anybody going after the people on Craigslist, individuals, but certainly any retailer, any company cannot resell these cribs. And in fact, the more, I don't want to say reputable, the more formalized, the more companies like eBay and Amazon, they stay abreast of these issues. But Craigslist sees itself more as a direct conduit between individuals. So they don't necessarily research and then go in and ban anybody selling these products.
Let me ask you a question. when something's sold as is, do you think that the manufacturer that you give up your rights against a manufacturer? That I can see.
The difficulty in a resale, not necessarily, if the defect is something that the manufacturer knew or should have known was occurring. If it's been altered, if someone alters a product and it would kind of break the nexus between the manufacturer and the claimed defect, I would agree. However, a manufacturer can be held for liable for foreseeable misuse of a product.
Foreseeable misuse.
Foreseeable, and that's always, in all of this, it's what is foreseeable, what a reasonable person
Yeah, the
would do.
reasonable man.
The reasonable. Now
Boy,
we
that-
say
that
reasonable person.
stays- oh, they say reason. They don't say reasonable
Person.
man
Well,
anymore?
some say
They
that,
say reasonable
Yeah.
person.
A few years ago, we started to see reports of toys manufactured overseas that were causing problems. Are you seeing more of this now because we are manufacturing so many goods overseas?
More and more. It has been going on, as we know, for years. The tricky part, I'm thinking of a number of cases. I once had a lawn chair that was bought, I want to say it was at Bradley's way back, which gives you an idea how long ago.
Yeah.
Mrs. B or whatever.
Yeah,
right?
Mrs. B, I remember that.
And the person sat down in a plastic armchair, and it snapped. The arms, as they went to sit, just totally snapped and chopped, amputated, partial
Oh.
amputation of a finger.
Oh, my
Something.
God.
And one of the difficulties was there was nothing on it to indicate who manufactured it. And what the law holds in these cases is that anyone in the stream of commerce is potentially liable.
When you say stream of commerce, you mean I sold it to her, she sold it to this one sold
Not
it to
so
that
much
one?
individuals. I'm talking more of the companies.
No,
Like
the
say-
Distributors.
companies.
Yes.
Distributors.
Yes, the manufacturer might be some unknown or virtually.
Oh, boy.
And if you look at certain products, I'm fairly convinced that they intentionally don't tell you on it who made it. But a lot of the products you might buy, and I'm not singling out any companies, but major retailers, Walmart, Target, on and on, they may have their own label. Some, not so much those, but sometimes you get. It could even have the name of what we think's the manufacturer, but it's actually made overseas. So whoever, any manufacturer, distributor, supplier, retailer,
They were all open.
they're all, for that very reason, because they're all held and to that reasonableness standard. There's also potentially breach of warranty, express and implied. I don't want to overly complicate things, but it's not just negligence.
What about food? Do you get into any cases where food or beverages
Sure.
are implicated?
It's not an area that I have handled many of, but that is a growing area.
What comes
in
to
the
mind
law.
is the famous McDonald's case with the hot coffee.
And
Yeah, talk
I'm glad
about
you
that.
brought that up.
Wasn't that appealed? Was that appealed? Or
Well,
what
that was
happened with
appealed. What most people know about it,
That the woman...
this is the sort of case that if you just would read reports or what most people's understanding of would end up in the final segment of your show.
Oh, you've got to be kidding.
You've got to be kidding, right?
Yeah.
Because most people believe, and what they've been informed, is that a woman bought coffee at McDonald's, that she put it between her legs as she drove, that it spilled, she got burned, and that she was claiming they should warn you that coffee's hot. And everybody laughs about the warnings, and that she got $2.9 or $2.7 million. A runaway jury.
Third degree
So
burns.
you've got to be
Yeah, you
kidding.
You've got to be kidding.
But
Yeah.
there's another side to the story. That's the factual side. And in that McDonald's case, she was not driving. She was a passenger in the car. They pulled up to the drive-in window at McDonald's. They got the coffee, styrofoam cup. They pulled over in the parking lot and stopped. They weren't driving. It spilled. It was so hot that she suffered third-degree burns over, I think it's about 6% or so of her body, all over her, the best way I could put it is her lap region. She required, in her thighs and so on, she required skin grafts. Her initial hospitalization, the medical bills were approximately $10,000, $11,000. She went to McDonald's and said, on her own, she had never brought a lawsuit in her life. She said, I'd like you to pay, would you pay my medical bills? They said no.
Oh.
She wanted $11,000. She then needed further skin grafts. They wouldn't pay her medical bills. She ended up with $20,000 in medical bills. So she went to a lawyer and said, I'd just like them to pay my medical bills. They refused.
She didn't have insurance.
I gather not. They went to, they approached McDonald's again. They would not pay. So the lawyer filed suit. She initially was seeking, she wasn't seeking millions. They went to mediation in the case with McDonald's, and the mediator independently suggested, based on the facts, which I'll tell you more of in a moment.
Explain what mediation is.
Mediation is what they call a form of alternative dispute resolution. And the parties, either voluntarily or sometimes it's court-imposed, will sit down with a third party, many times a retired judge or an experienced attorney, who will try to mediate to work out the dispute by talking to the parties, try to reach a settlement.
Okay.
The mediator made a recommendation of that they should pay approximately $225,000, somewhere just over $200,000. They refused. So then the case proceeds through litigation. In the course of the litigation, it came out, and McDonald's freely admitted, that they intentionally caused their coffee to be hotter than all their competitors to promote sales. The hotter the coffee, people liked it. Approximately 190 degrees, 180, 190 degrees. Most providers, suppliers, sell it at about 130 maybe or so degrees. So significantly, well documented that the risk of burns and the severity of those burns at that degree of temperature
It's probable.
was third degree, was skin graft, was major risk of burns. McDonald's was very arrogant. McDonald's admitted all these things. So basically McDonald's said, we'll put our customers at risk so that we can increase sales. And I wasn't in their boardroom or wherever these decisions were made, but you can surmise that they said, well, increased sales will reap us, 120, 50 million, billion served every day, right? Versus the threat of lawsuits with insurers, they made a cost benefit, which is something that corporations do. So at the trial, it came out, all these facts came out. When you hear of millions and punitive damages, you know the jury got angry. And they got angry because of their arrogance. They got angry because it came in just as I said, all that evidence. So she was awarded, and I don't have the figures right in front of me, but her compensatory damages, the damages that the judge asked them, instructed them to award as far as compensatory damage that were judged to fairly compensate her for her burns, was approximately 200 or so, maybe 300. I think it was 200-some thousand dollars. The jury, and this never gets reported, the jury reduced that amount by 20% because they did find she played a role in spilling the coffee, not driving along in her lap, but that she, so that was reduced. You never hear that. That's never reported, number one. So the compensatory damages were reduced by 20%. The next interesting factor is the judge in that jurisdiction, they have punitive damages. In Massachusetts, we do not have punitive damages except in very limited circumstances, and perhaps wrongful death.
Explain for our
Punitive damages are, I mentioned compensatory damages, and that would be the fair amount to adequately, fairly compensate someone for their injuries. And the factors would be the severity of the injury, the permanency, the amount of the medical bills, the extent of their pain and suffering. So in the McDonald's coffee case, that was judged to be $200,000 or so. And I apologize if I'm slightly off, but it's in that range. And then punitive damages are just what they sound like. The jury's instructed, punish them. They were in bad faith, they were grossly negligent, and now your job is to get them. And they were instructed that. Well, how do you punish McDonald's? How do you punish General Motors? Do you say $50,000? And in fact, that's the purpose of punitive damages. They have acted so outrageously that they are now to be punished. And in fact, the amount, and I believe it was about $2.7 million the jury came back with.
They must have said, McDonald's must have said, you've got to be kidding.
Yeah, no, actually, Roberta, it was the jury who said, you have got to be kidding McDonald's.
Really?
Well, they're saying, are you kidding us? Look what you've done. You were arrogant. You knew all this. You intentionally put your customers at risk. And exactly what you knew, not even should have known, they actually knew that the severity of burns at that level would result in skin graft, third-degree burns, and so on. So
they didn't win on appeal?
The story goes on. We can spend a few hours just on this because it's fascinating.
It is.
The fact is that the judge then, after the jury came back, and I should mention the 2.7, that was 2 days of coffee sales for McDonald's. Whether it's nationally or I don't recall. But that was so again.
I like coffee too.
Right. Well, it's now not as hot as it was, and now they have Newman's Own, I believe.
Yes.
So, and that's one thing when you do product liability law, you take note of all these products.
Yeah.
And,
Yes.
So the judge, there's something called, you might recall, remediator. It's also additor. A judge, after a jury has rendered a judgment, a verdict,
Takes away.
Can either add to it or reduce it. And in this case, he severely reduced it. And if I'm not incorrect, he reduced it down to like the $400,000 or so range in punitive damages.
So it didn't hurt them that much.
Well, it goes on from there. Then you mentioned appeal. I believe they filed an appeal or just maybe notice of appeal, but at least a threat of appeal. The parties then entered into negotiations, and there was a settlement which ended up being subject to a confidentiality agreement. So no one knows the amount. She certainly didn't get more than that.
Right.
And so she ended up with, most likely, significantly less.
Meanwhile, she's still got that pain and suffering that will never go away.
And meanwhile, the insurance industry and the media uses that case time and time again to say you've got to be kidding.
and they probably, that's the reason for these more warning labels too, that they get 20 pages of warnings.
Yeah, that case is not the reason. They report it so that you think that's the reason. The warnings and adequate instructions, a product can be, is principles of engineering in manufacturing a product, and your first duty is to try to eliminate any defects or hazards that you can. And if you can't, you then have a duty to warn, adequately warn the user. It gets, that's a delicate area, but clearly there are, the theory is that the manufacturer, the retailer, they're the ones who are in the business. They're the ones
fascinating, isn't it?
With the experts. So they're the ones who receive reports. They're the ones in position to know what's going on out there with their product.
There's new products all the time. We have to have you back because we've just, I mean, I just know we just touched the little surface of it.
I have a case. I'm sure everyone who here has heard of this. It was quite a few years ago in Rhode Island. I used to work about a mile away from the Station nightclub in Warwick, Rhode Island. That burned.
Oh, sure.
Okay. Now, it sounds, I don't know the details of this other than what I do know is it was the acoustics, it was the materials used for the acoustics on the stage.
Sound tiles for the soundproofing,
for the soundproofing.
Or to reflect the sound, correct.
So this particular material was more subject to be more inflammatory.
Right.
So would it be likely in a case like this, if the manufacturer of these materials, obviously they knew that in many cases it's going to be used, where there are pyrotechnics? That's what happened. Pyrotechnics caused the fire, and it exploded. And
I would say in that case, and it's an interesting question. In fact, I'll research it to try to find out, and I'll see if I can find out for you. Because obviously the nightclub had severe liability, but they had limited resources.
They had more people in there
The
than they should have.
pyrotechnic company potentially had, if they're for indoor use, which I don't recall offhand. So did they properly instruct and/or warn of the hazards of using the pyro?
They sued the brothers and and everybody who they thought should have known. Or
if I recall, they didn't have proper insurance.
Right.
That may have been, so they're trying to...
And there was also a question of the fire department inspection, whether that was adequate or not.
There were all sorts, and there were doors locked, I recall.
Yes, yeah.
We're going to branch into you've got to be kidding, but
Sure.
from that too, you're talking product liability, and comes new fire department regulations that they said that public gatherings, that they have to have sprinkler systems. I don't think there was a sprinkler system. And not just in Rhode Island, Massachusetts.
Yes.
Probably all
That's right,
over.
it did come from there.
I know we're short on time, but I do want to say that is what appeals to me most about product liability. It's not just helping one individual. It's potentially changing standards and preventing further injuries and so on.
That's the
and
good that come out of the bad.
You must...
So any consumer should check with products, particularly child products. Check online. Do a Google search. There are databases to see if products have been recalled. That's a good way nowadays. It's a resource that didn't used to be out there.
Thank you.
And you just touched on, you must be more aware of it than the average person, because you just touched on some of it. Like there was warning, all these warnings on pills. That's probably one of your biggest. That's a product liability case, isn't it? The wrong
Pills
pill.
are,
They
yes.
give you the wrong pill. How about the warning on birth control pills? Do not use if you are pregnant or may become pregnant. I mean, that some of these warnings, we were talking earlier about the warnings on the side effects of medicine. Do
Several
not,
pages in your favorite magazine.
If you become depressed or suicidal tendencies or side effects of death or any of these, and if you're experiencing any of these, you're just laughing. Yeah, you experience death. Yeah, you're going to call somebody.
Right.
But there's others. All these. Read some. These are
on the
warnings.
pepper spray.
These are warnings.
The pepper spray, it says never aim the spray at your own eyes.
You've got to be kidding.
And hair dryer, curling iron, and/or radio do not use in bathtub while bathing.
Yeah, you're kidding. I mean, there's common sense. There's this one here. I don't know if you should read it.
In Britain, they have warnings: milk may contain dairy products, peanuts may contain nuts, and yogurt may contain dairy products.
Yeah, the list
Well,
is
there's
endless.
a reation we fought the revolution, apparently.
But they say that in McDonald's coffee cups, they go warning product may be hot. But they have so many others. There was one where this is a funny one on an air conditioner. The label on the air conditioner said, "Do not drop out the window."
And how about this one? Sleeping pills, the warning said it may cause drowsiness.
And then, the lighter, don't light near your face. Oh, matches, caution, contents may catch fire. I mean, these are all real warnings that they're putting on products. They must be so afraid.
They certainly are afraid, and it's a problem for manufacturers and companies, the cost of insurance, and I'm sure somebody listening who's in that field would have that reaction. Yet there is information that needs to get communicated to the end user, and a number of the products you mentioned, I actually can think of cases.
That's why you got to come back. You
that
were
would be my
really
pleasure.
Great. I mean, really
You can see that
fascinating.
you know your stuff really well. You just
Thank you.
it exudes from you.
You really feel it.
Yes.
So remember about Live at the Library, that we're in 11 shows.
We're on 11 towns now. Besides Sharon, there are 10 more towns.
Wow.
So please check with your local listings. We also have Live at the Library series of open panel discussions. Please look in the newspaper to find out. We'd love to have you there. And most importantly, we need to hear from you when you have ideas. This topic really came about because of emails that we received. Please make sure that you stay in touch with us because we want to hear from you. Remember, this is your show. The law, your money,
And you.